all the power.
I don't know that you want to give lawyers that kind of authority, but sure.
I think I do. I think I'm ready.
Fair enough.
Might be a more smoothly running world soon.
Well.
Okay, so it's 11:02. I'm going to go ahead and just start the presentation as everybody else is rolling in, if that's okay with you guys.
Absolutely.
Awesome. So you are in the webinar for the LEEDing ladies, which is amazing. Thank you guys for being here this morning. Good morning, everyone. If you don't mind muting your mic whenever you get in, I believe everybody already is, but just to be sure, to be safe with all of this. About to get started, just a minute, obviously, but we will be taking questions throughout the webinar. So if you guys have want further information, or if you have a comment that you want to make, feel free to just use the option in the participant box that says raise your hand. So you'll just click that button. I'll be able to see it pop up, and I can interrupt the presentation and let them know that you have a question. Either that, or you can use the chat option and chat it over to us, and I will present that to both Jennifer and Kathleen. And yeah, and other than that, we will be taking questions at the end as well. So if you want to wait and hold your question for the end of that, this totally works for us. And with that, we wanted to say thank you. If I can get this slide show the way, there we go. Thank you to the LEEDing ladies. We're really excited to have you guys back for episode 3. The consequences of consequential damages. I can't believe I just got that out at 11 a.m. I'm pretty proud of myself. And if you guys want any more information about them, they are with HuntOrtmann, and they have amazing, it's a construction firm, correct? You guys mostly work with construction litigation? I don't know if I'm using correct legal terms. So.
Transactional and yeah, no, you got it. So we're with HuntOrtmann, who is predominantly a construction-based law firm. So we do both the transactional and the litigation side.
Awesome. Well, thank you guys. We're excited to have you, and I will hand it over to you guys now. Let me stop sharing.
Thank you very much.
Thank you.
Thank you.
All right, so I'm going to go ahead and share my screen. All right, so hello, good morning. Thank you everyone for joining us today. I'm Jennifer Tung. I'm here with my colleague Kathleen Smith, and we are from HuntOrtmann. So we want to thank you for joining us today for this 3rd installment of LEEDing Ladies. We are going to be talking about the consequences of consequential damages. And if you missed our previous 2 installments, you can find them online at USGBC's website, where we talked about designer's risk and also force majeure provisions during this COVID-19 pandemic. That episode was called May the Force Majeure Be With You. So if you want to find either of them, you can find them online. So today, though, we are going to be talking about consequential damages, also known as unique snowflake damages. They're not really. They're often referred to as special damages, but you can think of them as unique snowflake damages. But before we talk about that, I want to take a step back and let's talk about damages in general. So in normal life, in the real world, damage is harm. And in the legal sense, it's also harm. But when you're talking about legal damages, you're talking about harm distilled into an amount of money the court says you are owed because something went wrong. So whenever you hear lawyers talk about damages, they're talking about money. So there are things called general damages, which are different from special damages. General damages are the typical thing you think of when a party is harmed and they want to be compensated. So let's say you contract to have a brand new kitchen built, and you know, something goes wrong. You have to hire a second person to fix the thing that was built incorrectly. That amount of money that you spend to fix the work are your general damages. In contrast, special damages arise out of specific, unique circumstances that are unique to those parties or to that specific contract. Generally, those kind of unique circumstances or expectations have to be communicated to the parties before they enter into a contract in order for someone to recover them as legal damages. And the idea behind that is if party A is going to be able to recover special damages from party B, then party B has the right to know that before they enter into a contract, so they know the kind of risk they're signing up for. So after all of that, really what are special damages? So some real world examples are things like lost profit, loss of use of a property, for example, specific to green buildings or sustainable buildings. Parties can try and capture unrealized energy savings or loss of government incentives like tax credits as consequential damages. Let's take the idea of lost profit or lost rent as an example. So let's say an owner contracts to have a brand new apartment building built. It's built according to the design specs, but let's say that the completion is significantly delayed. And so the owner may try and recover the rent that was lost from all the time that they couldn't rent the building out because it wasn't done on time. The owner might try and recover that lost rent as a consequential damage.
And just to jump in really fast here is that with delay damages in particular, you're probably most familiar with seeing those in the context of contract damages, because a delayed project is often, if there are damages associated with that, additional overhead, your general conditions, things of that variety, those are still treated like contract damages as opposed to being in this kind of very unique category of consequential damages. So in Jennifer's example, the lost profit component isn't something that you would normally be able to cover under the general formulas that you use in calculating a construction project's delay damages. So this is one of those areas in which you have to be very careful about what monies you are identifying as your actual damage on a property, because there are going to be things, or a project, there are going to be components of a delay damage that are true breach of contract claims. They naturally arise out of the performance of the contract. But with lost profit is something that is going to be somewhat unique to a particular project, like the one in Jennifer's example, that, there is an additional component that would not otherwise be available unless you satisfy the requirements that would entitle an owner, usually in that particular instance, to the recovery of lost profits. So there is this kind of weird shifting of boundaries, that there can be something that is very common and accessible to you as a contractor or as an owner that you're much more aware of. But then there are these little outliers that are really important to keep in mind as you move forward.
And that's exactly right. And Kathleen hints at, how thorny and complicated the idea of damages and special damages can be. And that's true for green and sustainable buildings as well. In a traditional construction dispute, the owner, the contractor, the designer, they're likely evaluating the finished project by comparing the as-built condition to, let's say the design specifications. In a quote green construction dispute, though, an owner is very likely evaluating a project at least in part based on the performance specifications. A contractor may build a quote green building completely in accordance with the design specifications, but for whatever reason, perhaps the completed building falls short of the expected performance specifications, or perhaps it falls short of obtaining, the points that the owner had anticipated for some, green certification, like a LEED certification, for example. So then that creates its own, set of hurdles as well that are unique to green construction projects. For example, a lot of the evaluation of performance specifications can be based on third-party scoring. You can't control what a third party may or may not decide, the points that the third party may or may not award. The standards by which they're being evaluated can also be subjective, and so it creates potentially a lot more uncertainty than in traditional disputes. So it's something to be aware of. But at least with the LEED certification, there is a review and appeals process. So if the parties disagree with a decision, I believe there's like a 2 reviews and an appeal. So you at least have that avenue.
Yeah, and I don't want to leave this slide without having, a conversation about the differences between design specifications and performance specifications. Because although the relevance in the green building industry are very obvious because indicated, most often owners are going to be looking to invest this kind of money in these projects in order to achieve a specific level of performance of, the structure. But the same principles that apply to design specifications and performance specifications outside of the green building industry are applicable. They haven't changed. So just to kind of restate, when you have a design specification and a contractor builds per that particular specification, the risk of a failure of the design is owned by the owner. That is a very tried and true staple in the construction law industry. It's often called the Sparrow Doctrine, where the owner will own the responsibility for providing a contractor with a buildable set of plans. Now, this is obviously contrasted a little bit with performance specifications, which don't go into all of the grisly detail into what the contractor has to do. So with this performance specification, there is more risk that is shifted to the contractor to achieve a particular performance level. There are a number of subcontractors and trades that essentially have been doing design build work for, in order to have their systems work. HVAC is one of those areas that you often see design build work. But with those, they're often performance-based, is that there's an actual identification of what needs to be achieved in order for the system to be operational and approved. And a failure to achieve that particular level of performance is then the responsibility of the contractor. So there is this ability that owners have always had to shift some of the risk of achievement to a contractor, which would not ordinarily be there. So under a standard contract, you're really going to often see the design specification. It's usually going to be that the design risk is owned by the owner. And only if there is a change in some of the dynamics and the roles within the contract will you start seeing more and more risk shift over to a contractor or a subcontractor. So while we're talking about this in the green building arena, I don't want to lose sight of the ways in which a lawyer, any of your legal consultants or a court would be evaluating these under principles that have been long available to the construction industry. So we do have tools to draw from, even though some of these technologies and some of the performances that we're starting to see within the green building industry are somewhat different and innovative.
And so in this next slide, we'll get to see an example of what happens when parties don't shift risk the way that Kathleen has been talking about, and a dispute arises. This is a case out of Maryland. It's from 2007, called Southern Builders versus Shaw Development. It's often referred to as the country's first green building litigation. So this is a dispute that arose out of a multi-million-dollar luxury mixed-use building project. It had condos and restaurants in it called the Captain's Galley. There's a picture of it right there. So the owner here wanted to take advantage of a state green building tax incentive where the owner would get an 8% tax credit if LEED Silver was achieved and if the project was completed by a date certain. The project wasn't completed on time and LEED Silver wasn't achieved. And so because of that, eventually everybody just essentially sued each other. The general contractor pursued a mechanics lien, and the owner sued for breach of contract and negligence. So the owner claimed that the contractor failed to complete the project on time and failed to meet the LEED Silver rating system. Because of that, the owner wasn't able to achieve the 8% tax credit, which he then said was worth over $600,000, which the owner tried to recover from the contractor. This case eventually settled out of court, so we won't ever really know how a court would have ruled. But some of the things that went wrong here was that the parties used a standard construction contract. Nowhere in the contract or project manual did it say that LEED Silver had to be achieved, that part of the deal was that the owner would achieve this tax credit. Pretty much none of that was mentioned. And so it goes back to the original idea of what's a special damage. There was no evidence, at least in the contracts, that this LEED Silver rating or the tax credits were contemplated by the parties, were agreed to, were discussed, that the contractor or designer knew that this was what the owner had wanted. And so if the case had proceeded, those would have been significant hurdles that the owner would have had to get over. And I suspect that that's probably a good reason why it eventually settled, was because the contract was so silent about these specific goals.
So now what? We've talked about just some of the ways in which there's an intersection between consequential damages and how it's traditionally characterized and treated, and green building. And I do want to go back to kind of a fundamental principle here, is that while the reported case law in connection with how courts would treat damages, especially consequential damages within the green industry, remains very sparse. I'm sure that if anyone has seen a similar presentation on consequential damages in the green building, they've probably heard of the Shaw case, because the Shaw case is one of those examples that it started the conversation. But because of the settlement and because so many construction contracts now have arbitration provisions in them, there hasn't really been that final conclusion in this particular chapter. But we do draw on fundamental principles that have always existed within the legal industry, and specifically within the construction legal industry. So we talked about it a little bit before, but standard construction contracts in the green building industry, will often leave things out. And so how do green builders, how do designers of green projects and owners that are pursuing these types of projects really understand and address this gap within the standard contract language, because we aren't really truly dealing with an exact apples to apples comparison, because there are going to be additional reasons why an owner is looking to green build instead of just doing a straightforward design bid build project that, you know, you've provided the design specifications and now just go and build it the way that I told you to. So one of the things that's going to be really critical to anyone who's engaging in this type of construction project is going to be to understand the project's priorities. If there really is an essential component to these projects that the owner needs to achieve a certain tax credit, needs to achieve a certain LEED certification in order to market property in a certain way, those are conversations that are very critical to have at the very beginning of your project, before the contract is signed, when you're actually ascribing roles and responsibilities. It's often a very hard conversation to have, but the most successful projects are the ones in which the tough conversations come before anyone has signed on the dotted line. So when you are actually engaging in this type of project, to understand what risk you're truly taking on, you do need to know what the project's priorities are and what the expectations of the owner and the ownership are. The next point is to set clear goals. Nope, don't go yet. It's setting clear goals. And as we indicate in this slide, saying sustainable or green is not enough. We have case law that we don't have within this particular presentation, given the limitations on, you know, the time that we have with you today, but that there are these vague references to, you know, having sustainable building, or that you want a green construction. Those terms are so amorphic and they don't really mean a whole lot to a court who is, after the fact, analyzing what everybody's intentions were at the time that the contract was entered. So when you're actually looking at what to do and how to address these types of issues, you really have to do it at the time that the contract's being negotiated. Waiting until another day until you actually hit a particular obstacle is often going to be too late, at least when you're dealing with the courts. Courts are going to look to the day of contracting and try and piece through your contract to see if they can identify what the expectations and the intentions of the parties were when they're actually looking to see who is going to own a certain risk. And you don't want a judge having to make that determination. To the best that you can, you want to assign those rights and responsibilities early on. If not at the contracting stage, then within some of the contract and the project documents. I can tell you that it is very hard to recreate, and it's never perfect. So, you know, the best that you can do at the beginning is going to be the best savior at the end. Now you can go to the next slide. And during this conversation, there really has to be a discussion about whether or not to waive or not waive. Obviously, if you are on the ownership side of a green building project, you're going to want to identify the ways in which you could be potentially damaged should the project not achieve a particular certification, so that you can actually, you know, recover some of the investment costs. Because we're not sitting here talking about the fact that we know that green construction in the price component is comparable to doing it in a more traditional way, where you're not being quite as conscious of the new technologies and some of the waste restrictions that are put on green building. So as an owner, you want to make sure that you have this right balance of risk that you're taking on, that of course there are going to be some intangibles. No one can ever truly take control of an inspection. An inspector has his or her own set of biases, and, you know, hopefully you can maneuver through the process and make sure that the certifying agency sees all of the information in a very objective way. But you can't guarantee it. Contractor can't guarantee it. A designer can't guarantee it. And you as the owner can't guarantee it. But what you can do is look for ways of making sure that you are adequately protected, and making sure that those particular construction or those provisions make it into your construction contract. Obviously, if you're the contractor, you're going to want to limit the additional damages that you are taking on when you are pursuing this type of project. Obviously, there's going to be some things that are outside of the contractor's control, the design being one of them, unless it's some type of design build, and that has its own risks and rewards. But you do want to at least identify in the very beginning what the expectation is of the owner. So if you have a provision within your contract that says that there are consequential damages, that consequential damages may exist, there could be lost profits, there could be, lost savings, tax credits, things of that nature. You want to know that at the beginning end, or the beginning of the project, so that you can account for the types of risks. You can modify your behavior at the beginning in a way that you can't at the end. So there's always this push and pull during the negotiating process that almost has to happen. And if you're a contractor and essentially the owner says, no, absolutely will not waive consequential damages, it is that important to my investment to do this green building project, then there is another level of negotiating that you can go into, which is actually starting to identify specifically which types of consequential damages you may be subject to. You might be able to exclude some of the damages that may dwarf what you would otherwise see in the just kind of straight construction contract damage analysis. So you do want to be mindful that just because you can't completely negotiate out of a contract consequential damages doesn't stop the conversation, that there is another layer that you can present to see if there is a way of adequately balancing the rights and the risks of both parties.
And these are the kind of negotiations and discussions, difficult as they may be, that likely would have helped the parties in the Shaw matter if they had had them with each other before entering into the contract. Like with any relationship, right? A construction project is a relationship among parties, and it benefits everybody to enter into this relationship with their eyes open. Owner, by having these conversations, the owner can be sure that everybody's on the same page as to what the goal is, and the designers and builders know what risks they're taking on. And it's possible that they did have these conversations, but we'll never know because, like Kathleen also mentioned, courts look at the documents, as they are written. And if the documents are silent, like they were in Shaw, well, then it's like those conversations never happened.
That's right. And that's something that people often forget, is that there are some opportunities for people to show by conduct what the intention was. But whenever a court is looking at it, they are always looking at what the intention of the parties were at the time that the contract was entered. So if those priorities change, that's a change order. It's not just trying to make your conduct fit this new and improved or this changed priority. It's very hard sometimes to recreate where everybody's heads were on the day the contract was signed. That date is of critical importance when you're dealing on the legal end of things. So in connection with this green building, the major issues that you are going to be looking at and evaluating for whether or not they will subject you to a claim of consequential damages are the ones that we've talked about. We've talked about the cost savings, the risk to it. There is often an upfront commitment to green building that an owner is willing to take because of the cost savings that they achieve at the end of the project, the life cycle costs of the building. And if they can't achieve those, then it becomes very hard for investment into these green building areas. And, this is a moneymaker. This should be a moneymaker. The better these projects are and the more successful they are, the more likely they're going to be, into the future. So there is a real value when there are savings that are lost in the life cycle costs. Tax credits. Not happening quite so much right now, but, it's something to be mindful of, is that, again, a lot of the return on the investment is looking at the whole package and seeing how investors can maximize on the tax credits that are being given for green building. Guarantees. If you're a contractor in this industry, you have to be very careful about guarantees that are integrated within the contract provisions. And it may not just be a single provision, it may be peppered throughout the contract. Obviously, as a contractor, you want to be more mindful of that, because there are a lot of intangibles that are outside of your control. And if you have to go through the appellate process, who's going to bear the cost? Because that is an additional cost. That is lawyers, that is consultants, that is a reevaluation of the documents that have already been previously given to an inspector. So there is danger within that. And if you haven't gone through and made you adequately understand what you have signed up for, what achievement you have signed yourself up for. Have you guaranteed, or have you said that you will use your best efforts to achieve a particular certification, and that you will assist the owner in support of any type of certification that it pursues? You know, those are very different legal obligations, and knowing the difference between, you know, a guarantee and an assistance is often one of degree rather than a clear, bright line. But of course, you know, like all things in law, there's always some ways that you can, you know, assist yourself, help yourself into the future, lay the breadcrumbs so that you can find your way back. Taking a special look at the project specifications. I will tell you that I personally have been involved in several cases that about when we were dealing with a design or a profession. So attention does need to be paid to these project specifications to know whether or not you're signing up for a project that is design-based, or if it's performance-based. And again, this is one of degree very often, as opposed to it being a very clear-cut, solid, you know, all in one camp. Of course, there are those cases, but those aren't the cases that get litigated. You want to make sure that you're also identifying what industry standard you're having applied to the performance of your work. That is something that can be negotiated. It often is negotiated. And depending on what type of project delivery method you are using, you may have different standards. Your GMAX contracts say something totally different than your, you know, lump sum contracts. So the more you are in tune with what you have signed up for, the better off you are either negotiating something more accurately represents the risks that you're willing to take on, or the roles that you expect somebody else that you're hiring to take on. In addition, you know, we're going to talk a lot about, or we have talked a lot about negotiating, is that if you have a performance-based specification, or if there is a guarantee or something that goes beyond what a contractor would normally have the risk of performance, you can add provisions to your contract where, as a contractor, the contractor gets the first right to cure. And even within that right to cure, there are, you know, there's a whole branch of, you know, additional rights and obligations that you can discuss, up to and including how much cure do you have to put in before it becomes more of a shared risk, before it is build me a hole for free. Because you have to think about things like that, because I think that it's very important for a contractor who's going to know the building, you know, better than anyone, to have the first right of being able to fix something. But when does that fix become too much, and it becomes too much of a risk as compared to what was already negotiated within the contract? Having to build a whole new building, that seems unreasonable. But, you know, what we're going to be looking at as lawyers and as courts is, what did you say at the time that you contracted?
Right. And like Kathleen was saying, you know, especially with the retaining the right to cure, it does open up a whole branch of other obligations and, you know, potential risks to think about. And some are unique to, you know, green building projects. You know, for example, if the specs require, you know, some kind of cutting edge or bleeding edge material that hasn't been tested before, or perhaps the manufacturing pipeline is new and hasn't been tested, you know, what happens if that material doesn't perform the way it was anticipated to perform, or doesn't get to you on time? You know, is there an equivalent material for this brand new material that everybody was super excited to try? So, you know, you know, in most things in law, there are no clear-cut answers for that, but something important to bear in mind during that negotiation process.
Okay, and so for anyone who has listened to any of the presentations that we have given, either as the leading ladies or just under our regular banner at HuntOrtmann, you will know that one of the things that I in particular stress so much is good communication and relationship building. I am both a transactional and litigation lawyer. So I see it at the front end and I see it at the back end. And the contracts that I am often asked to litigate because the disputes are too hard to overcome are often the ones where there wasn't enough attention paid at the very beginning of the project to set everyone up for success, the project up for success even. So it's one of those things that I'm a broken record on, and you know, I apologize, but I don't, because you will see me at some point in time, and you know, one side is a lot cheaper than the other. So you know, the reality is that the best projects are the ones in which people communicate and communicate well from the very beginning. And sometimes that means that you have to have very challenging conversations at the front end, because at some point in time there is going to be a challenging conversation. You need to know who you're dealing with on both sides, and you need to know what you're dealing with. I have also recommended to some of my clients who are going through what I consider to be unreasonably harsh contract negotiations to walk away from the project. Is that if you are encountering someone at the very beginning who is so unwilling to see reason, they are showing you who they are going to be for the entirety of the project. And while it may be great, a great resume builder, or, you know, really cool project, you know, something that you just would feel very proud of at the end, you may not feel that way if you move forward, because it might just be a nightmare project that you don't want to be, you know, involved in. And so what you thought was going to be a $2 million profit for you could be, you know, a $2 million hit. And, you know, they often go that way. It's hard to predict what's going to happen. But with consequential damages in particular, it's one of those instances where you do have some control. You do have some control in identifying what you can expect at the end. I know that if I don't hit this, I am going to be responsible for that.
And that's exactly right. You know, we stress it all the time in our presentations, you know, communication and good relationship building. And especially now, if ever there was a time for parties to be reasonable, then it's right now during the pandemic when there is so much uncertainty. And like Kathleen said, if you are, you know, negotiating with a party that is being unreasonable at the outset already, it often doesn't bode well for when you're actually on the project, because, you know, no matter how great relationships are in the beginning, construction projects can be big and can be complicated, and often disputes arise, and you want to know that that the parties have a strong enough relationship to be able to hopefully work things out, so that you never have to come talk to me and Kathleen, you know, once the project's actually gotten going.
So we have a question from John Bollinger. I'm not sure if he wants to ask it to the group or if you just want me to read the question.
I'd be happy to address it. Thank you for the opportunity. I've been particularly concerned with one aspect of construction, which relates to the amount of waste that is generated from both demolition and during the construction process. And of course, LEEDs has certain criteria. Of course, we're talking about LEEDs for recycling of materials, and more state and city requirements in terms of percentages of recycling of various materials is becoming important. I realize from your standpoint that these requirements need to be reflected in contracts, in agreements between owner and contractor, etc. Owners aren't necessarily the most knowledgeable. Of course, they have to rely on attorneys and other specialists, including designers, to be able to anticipate this. But because of my study of this particular issue, what I found out is that designers will typically include in specifications, and I'm talking about big design requirements, like, for example, the Metropolitan Transit Authority's construction of the subway system. You have major documents that require recycling, and then you have the contractor's proposals, and they are required to do waste management plans, all of which are supposed to be in compliance with this, and they seem to be following this requirement. And then what happens at the end of the day is you have large quantities of material, whether it's soil, whether it's concrete, other materials that are being excavated and demolished, that are simply taken to a dump site and dumped rather than recycled. And yet the way the process is handled from a permitting standpoint, the records are inadequate. I realize I'm going on, and I apologize for that, but I see this as a kind of a storm waiting to happen, in that in reality, a lot of these recycling requirements are not being met at local levels, and at some point there are going to be penalties. We talk here about tax incentives. There are going to be penalties, and that's as far as I want to go right now, and just asking you, number one, if anything has come up along these lines in your experience, or if you have any thoughts about how this aspect of recycling can be, how you can, to use your terms, avoid the consequential damages of this in the future. Let me stop it there. Thank you.
Yeah, so there's a lot to unpack in what you just said. And I like, for instance, that you have referenced some of the ways in which the public agencies are starting to get in on requiring certain recycling and waste disposal requirements, because, you know, these are large projects that do, and they are the types of projects that should be covered, you know, that should be driving some of the turn to green building. So it's going to sound like I'm going off topic, so just give me a little bit of leash here. With any public agency, every contractor, every subcontractor has to be very mindful of the fact that there are different rules when you are dealing with public versus private works of improvement. And just taking your example, that Metro has a requirement that waste is going to be treated in a very particular way, and that recycling is going to be treated in a very particular way. And let's be honest, it is much more costly to handle it in the way in which is being required by the agency than to just go and, you know, put it into that what you normally do. So there's obviously going to be the tension of obligation versus cost. And if you get that cost wrong, there's going to be an incredible responsibility by the contractor to ensure compliance with this particular rule. But with public works in particular, there is not much gray area when you certify that you have done something. And with a lot of these waste compliance requirements, there is actual certifications that you need to be providing to the agency to confirm compliance. And when you are certifying anything to a public agency, and that certification is tied to payment of money, you are opening yourself up for a whole host of problems in connection with a false certification to a public agency. California has very strict and very significant false claims laws that essentially make any false claim made to a government agency a per violation penalty. It also has treble damages that are associated with any actual payment that is made based on a false claim. So contractors need to be very weary of certifying compliance when they are not actually complying. And that is a cautionary tale that anyone who has been in the business long enough will at least be familiar with the long arm of the false claims rules. So while there are certainly these issues with the permitting, and there are certainly these issues and the costs that are associated with, contractors need to be very mindful of their subcontractors who are dealing with this kind of recycling and waste disposal, because they are essentially passing through those claims. And if they don't do an adequate due diligence process within that, then they could be unintentionally opening themselves up to at least a claim for false claims. And I will tell you that even a colorable false claim allegation by an agency against a contractor needs to be looked at and reviewed very carefully, because the penalties are severe. They can be the grounds for debarment. And if your business is based on public works, you cannot have an agency deem you not responsible. Big deal. It's a big deal. And it has to be treated, very, you have to treat it with the importance that it should have. So with that is the cost, is that, contractors do have to make sure that they are adequately addressing any kind of additional cost for the recycling and waste disposal on a public works project that has some kind of LEED component to it, that is actually requiring disposal in a particular way, that's having recycle to a particular percentage. And it can't just be a reliance on its subcontractor. There also needs to be a look more closely at any kind of provision in the contract that deals with differing site conditions. If you're experiencing more concrete, more dirt, more hazardous waste, whatever the case may be, when you're doing the disposal, that needs to be tracked. That needs to be formulated, and notice needs to be provided to the public agencies so that they know that there was an expectation that you would have this percentage, this cubic yardage of, disposable materials, and now we're encountering double that, quadruple that. So again, good communication and knowing your notice provisions within your contract are pretty critical. And then ultimately we do get to that final level of, if the contractor has not been diligent, if the subcontractor is not taking the adequate steps to comply with the disposal and recycling requirements, and they are certifying for payment that these have been done, there may be in there some, issues. And it's a very powerful tool that agencies wield. And, again, even if it won't ultimately survive a jury review, it doesn't have to in most circumstances. Jennifer and I will tell you that most of the cases that we litigate are settled. I mean, construction follows the regular model that, between 90 and 95% of all cases are settled before you actually get in front of a judge or a jury or an arbitrator. So that's pretty significant, because it's a very good, strong way for agencies to negotiate down any type of settlement. I work on both sides of the equation. HuntOrtmann has never chosen a side, so I represent owners with the same frequency that I represent general contractors and subcontractors. And I have the same spiel for all of them, is that when you're dealing with public works, you mind your P's and Q's, because it is a very powerful weapon in my arsenal when I'm representing an agency client. It is a very big weapon to be staring down the barrel of when I am a general contractor or subcontractors counsel. So I think that you're a very important one, because it essentially goes to, being honest and making sure that the certifications are not only being complied with and that the certifications are honest, but that there is, on the other end, if there's any difference of what you expected to see versus what you're seeing, the good communication, knowing your notice provisions, making sure that you're putting the owner on notice of some type of differing site condition immediately so that you can actually claim the additional cost for proper disposal. Having the tickets, making sure that you're getting the right tickets back from any kind of actual disposal within, within the realm of what you're supposed to be doing. And then also making sure that you're scratching below the surface to ensure that whoever is signed up to be doing the recycling is actually doing it. It's not just like throwing it into, a dump for somebody.
Amazing. So we have one more question also, if you have a second.
Yeah.
There's also one saying the consequential damages issue may be addressed between the owner and architect and then owner and general contractor separately. How do you cover the performance of the third party? Do contracts between the general contractor and subs also include consequential? Sir, not my normal language.
Definitely a mouthful. Yes. So, it depends on what type of model you're using, what kind of project delivery method you're using. So obviously, if you're doing design build, you've compressed those things down. So there isn't different obligations between the designer and the contractor, because oftentimes the designer is the builder. And we're dealing with subcontracts. And this actually, you can chime in too if you have any different thoughts, is a whole different ballgame. Is that subcontracts are challenging because they should follow the terms of the prime. If you are a prime contractor and your subcontracts do not accurately mirror what obligations you have to the owner, you really do need to scrub them and make sure that they flow well. Because just like, you want to make sure, you just want to make sure that the obligations you're signing up for as the general contractor are being appropriately flowed down to your subcontractors. So for instance, if you have a consequential damage provision in your prime contract, it is very important for you to make sure that in your subcontracts, you don't have a waiver of consequential damage provision. You are essentially telling the subcontractor, don't worry about it. You're only going to be required to deal with the damages that flow directly from the breach of our agreement. If you don't hook in the fact that you as the general contractor have made yourself responsible for loss of rent, lost profits, lost tax credits, you are shutting down a resource to balance out and proportionally ascribe risk. So it's an important mechanism when you're doing these contract negotiations, especially if you start being much more tailored in what provisions you're including in your prime contract. You need, with the same specification and the same attention to detail, make sure that you're doing the same thing with your subcontracts to make sure that you're not inadvertently leaving things out.
And the same is true going the other way up too. If you're a subcontractor, everyone should read their contracts. Just as a general rule of thumb, be familiar with the contracts. But if you're a subcontractor, you'll often have clauses that incorporate, the prime contract by reference. And so it's not only important to know what's in your subcontract and be familiar with that, but know what's in the prime contract too, because it's getting incorporated into your subcontract.
That's right. And conflicting provisions are a litigator's delight. And so if you have inconsistency within those contract terms, again, it goes back to what was the intention of the parties at the time that they contracted. And most of the time you are limited to what is in the four corners of your contract documents. And as everybody here knows, construction contracts in particular are many, many documents put together. They're going to be somebody to go through all of those terms, and they're going to cherry pick all of the provisions that support their position, which is likely not going to be what you want. So, it is best at that very beginning stage. As inconvenient and tedious as it is, it's so important to make sure that at the very front end of your project, you're paying attention to how those provisions intersect.
That's exactly right. Any other questions? All right. Well, thank you guys so much, and thank you USGBCLA. If any of you do have additional questions that you think of afterwards, feel free to give me and Kathleen a holler. You can call us at HuntOrtmann, or you can send us emails directly.
We hope that you guys are all out there and safe.
Thank you guys so much. That was really interesting. Every time you guys host one of these for us, I always like walk away being like, I wonder what it's been like to go to law school. So, and then I remember that I'm tired. So thank you guys so much. We really appreciate it. And thank you for providing everybody with their email address so that they can reach out to you. I'm sure that's a huge valuable resource for so many of us right now. I'm going to go ahead and start sharing screen just so I can wrap up today. So once again, we want to thank you guys, leading ladies from HuntOrtmann, who are our wealth of knowledge for all things to do with, well, I guess, legalities in general, which is amazing. Thank you guys for being here. We really appreciate it. So we have other upcoming webinars, trainings that are happening still, even before we have MGBCE in the next month. So we have our Net Zero Accelerator. We had the 2020 cohort release just come out. So we're inviting everybody to come out and meet with them. That's actually going to be this afternoon at 4 p.m. So if anybody wants to come and meet any of the cohort, the new companies that are really paving the way towards a net zero future, please join us today at 4. We have a few webinars coming up. If you guys would like more information on that, you can go to usgbcla.org and find all the upcoming educational opportunities that we're providing. We do have MGBCE, our annual event, which is always pretty massive. We're switching everything over into virtual this year. So we have 2 days of it. It's going to be, the first day is kind of primarily organized around green building. We're going to have keynotes. A lot of the workshop sessions are going to be similarly minded to basically what we were talking about today. Actually, there's a lot of things talking about the effects in the construction industry and how everybody's kind of seeing this layout with green building. So we hope to see you there for that. Day 2 is going to be community-based, which we're really kind of opening up to hopefully invite the general public to find out a little bit more about the green building industry. As I said earlier, with the educational opportunities, we have our talent portal, which is new. It was released about 2 months ago at this point in time. So all of our upcoming trainings, video recordings of this webinar will be available all on that. You can find that at usgbcla.com or .org/talent. And then we have our committees. So if you guys are, feeling the vibes of being a little bit distant from everybody right now, come join our community. We've got 8 amazing committees that are still going strong right now. There's monthly meetings. I think the number one question that we get from that is how do you get involved? And it's really just join in on a call. You can find any of the dial-in information online, and you can just hop into that, and you will be automatically enrolled in the mailing list if you would like to be from that point, and you'll just find out more information that way, and it just kind of gets you involved in our annual initiatives through those committees. And also, if you enjoyed this content today and would like to see more of it, please consider donating to our tiny 5-person team nonprofit. You can do that by texting GREEN to 707070. And we want to say thank you to our sponsors and to HuntOrtmann for making this possible today. So thank you guys for being here and for supporting, and we really appreciate you sharing your knowledge on all of this.
And thank you guys again for hosting us, and thanks everyone for participating.
Thank you. We hope